Good evening. This is already live here from Houston, Texas. Every Tuesday from 5 p.m. Central Time, we are live here from Houston, bringing in the updates of the immigration. What's updates today?
All right, we want to talk about something that is impacting a lot of people right now, and that's what happens when the company that you're working for is not filing the Perm labor certification. We're hearing more and more about these tech companies that are having the layoffs, now having to tell people that they did not lay off that, hey, we have to pause recruitment, we have to pause our whole labor certification program. How does that impact people? What options do you have when you're in that situation? Also want to talk about people who decide to return back to their home country and what types of things you should take care of, what you should know about that process. Common question we get is how and can I retain my non-immigrant status after I enter the U.S. on advanced parole? If you were on H1B or L1 or your family was on H4 or L2 and then you can't get the visa interview appointment, so you travel using your advanced parole and come back, are you still in H1B or L1 status after that? Can you still extend and transfer? And lastly, a common issue that comes up is what happens if your company is sold or is merged into another company, or there's an acquisition, some sort of change in ownership? How does that impact H1Bs? Do you need to file an amendment? Do you need to file a transfer? How does it impact labor certification, I-140, 485? So we'll go into all of those details, and of course, we'll answer your questions as they come up.
I mean, first thing is that now I've been recently told that Amazon put a brief. They said that they are not going to do any recruitment until October of 2023. And we also heard that Google is also not going to recruit. That means that most of these companies are not going to file any green card applications anymore.
Right, and Meta already was having
problems with that. And we may see that coming from Microsoft. So a lot of the major companies at this point of time are not going to file the labor certification application. Now, when that's going to happen, though, what's going to happen with the people whose 6 years H1B is getting extended? As you already know, all the people that you can only extend the H1B beyond 6 years only if you have the labor certification filed for more than 365 days or have your I-140 approved. And the requirement, one of the requirements for the labor certification is the company has to prove there is no American worker available. In process of that, they need to conduct a recruitment. That means that they need to try to hire US workers. But when they're having a layoffs, laying off the US workers at the same time, they're saying that they are trying to recruit US workers. It is contradictory. So some companies that are having these layoffs may not be able to file the labor certification. If your position is one of those kind of positions that may fall into that particular category, you need to look into the alternative things. What should you do if you're going to come to a place where your 6 years are ending? One thing we suggest is that it's do or die. I mean, you don't want to end up in a situation where your 6 years is not extended. So definitely changing to another company that may not have layoffs, that are still recruiting, may be a good idea, especially the smaller companies. May be a good idea because they may have a specific positions that may be more suitable to you, that they may want your skills. They can be able to file the labor certification and get you the I-140 approval. If you have the H4 EAD option, definitely that's an option that you need to consider. There are also options that if, let's say for example, if you're working for Google or Amazon right now, and if you have some other company, a consulting company that wants to hire, let's say some Deloitte or whatever company it might be, and they want to hire you, even though you're not working for the company, though, they can still file the Perm and I-140 for you. Let's say you're working for Amazon and there's another company that wants to hire you. Even if you're working for Amazon, they can still file the labor and I-140. You may want to consider those options. Just in case by any chance you choose to return back, let's say you got laid off and you choose, you're coming very near to 6 years and you choose, you don't have any option to extend the H1B, you can go back to your home country. Then you already know that you have to wait for 1 year before you apply in the lottery. But there are many exceptions available for that. For example, while you're in India, if a company files a labor certification, gets an I-140 approval, you can still resurrect your old H1B without going to the lottery system. So you may want to explore this option speaking with a lawyer. It's not a very rocket science in it. All you need is that find a company that can file a labor in I-140. Especially when the demand for the IT goes up, you'll find all these companies that will do all these extra tactics just to retain you and to get you from your home country to here again. And also people who are on H4 EAD, if people can move to H4 EAD, apply for the labor and I-140 approval, and then they can switch back to the green card though. Switch back to the H1B. That option is there too that you need to explore. Anything else? Somebody?
Yeah, and I would just add, if you're impacted by this, don't wait, because you may be thinking, oh, things will turn around and I'll just wait until they start up recruitment again, but you don't know how fast that's going to be. If they're going to start up recruitment in October, that means they have to redo the prevailing wage. Those are taking 7, 8, 9 months now. It's not, it's taking a long time. Then they have to go through their recruitment, and then they file, and the perm is taking 7, 8, 9 months. So every single process is taking longer and longer right now. Imagine what it'll be 6 months from now if they start up the process again. So I would not hold my breath and wait it out to see how things work out and wait for these companies to start up the process again. Take action now because it's much easier to make sure you get that I-140 in place so that you don't max out of your H1B. And I would also say that, one of the most common questions we get asked is, well, can I switch to B1 or can I switch to F1? That can be difficult, especially if you've got, a previous I-140 in place or something like that, because you have to show your non-immigrant intent, but having an I-140 petition is the opposite. The other issue is the processing time can take a year. You can only ask for 6 months on a B1, but it takes a year to get it. And so you have to file multiple extensions, and you're just going to have all of these extensions pending and nothing's ever going to get approved. Makes it difficult for you to later get back to H1B from within the US. You have to go out, do consular processing, get the visa stamp, and come back. So those are not, B1 and F1 are not great options, especially F1 if you're looking at one of these day one CPT type companies to be able to, or schools to be able to work. We don't recommend those. So just don't take too much time to act. Look for other companies, look for smaller companies. They may not have the big name, but they can provide more immigration benefits to you.
Question that comes on right now with the layoffs going on, some of the people wants to return their home country. What are the options that are available for them? One thing is that you need to watch for the social security though. If you work for 40 quarters, which is practically 10 years, I don't know why they call it as 40 quarters, but if you work for 10 years in the United States and have paid the social security, if you worked on H1B, you will be paying social security taxes though. You will be eligible for social security when you get to the retirement age, which is, I think, so is about 62 years. So please be watchful. If you're like 9 years and you want to return back, you may want to continue for 1 more year and be eligible for that though. A lot of people ask the question, I'm not a US citizen, I'm not a green card holder, I'm staying in India, can I still be eligible for the social security? The answer is simply yes. If you have contributed for 10 years, for the social security, that is 40 quarters, you are eligible even if you are outside the country. You're perfectly all right. So please make sure that you make sure that you cover the 10 years. 401k plans that if you are enrolled in, you can leave them as they are, because if you take them, you will have to pay the taxes and you may have to pay the interest, a penalty that may be a lot of burdensome. It may be better that you leave the 401k and you go to your home country and then withdraw at that point of time, because you may come into less tax bracket if you do so. So your tax may go down very low. That's what one of the CPS told. I'm just relaying that information. When you go outside the country, make sure that you pay the taxes for that particular year that you stayed here. You can do that online. Don't burn all the bridges, guys. I mean, make sure that the lease, give proper notice, complete those things. Any car that you have to sell, please sell it and go. And it's nothing bad going outside the country and coming back again. Please keep the bridges open so that you can always come back. Well, if you're going anyway outside the country, you have 60 days of extra period now you are being granted to stay in this country, I might as well go Las Vegas and Disney if I have little kids, or probably Yellowstone or some things before you go outside the country. Because what if you're not going to come back? What if you're not going to come back for a long period of time? I might want to consider that too.
Yeah, and remember, you can resurrect your H-1B in the future, whatever time you have left towards your 6-year limit. So if you've only used 3 years and you decide to exit and you stay out of the US for 10 years, 10 years from now, you can have another employer file an H-1B and get the remaining 3 years without going through the lottery. You're not subject to the cap at that point because you've previously held H-1B. A lot of people think, oh, I have to do that before the current petition expires or within 6 years of when I was counted. That's not the case. They made that very clear in 2017 with the regulations that came out at that time. So you can always get back to H-1B in the future if you have time left in your 6-year limit.
Question that is coming very frequently is people are traveling outside the country in advance parole and coming back. So question is, when assuming, Emily, that I have a H-1B approval until 2025 and my wife has H4 approval until 2025, if we both go to India and come back on advance parole, can I extend H1B and H4 when the time comes?
Yes, even though you're I-94, so when you come back in on advanced parole, it's going to only be a 1-year I-94. That deadline is not relevant because you have an H-1B approval notice, H4 approval notice, and when you get to the end of the H-1B and H4, you can extend it as if you were in H-1B that whole time.
Can I amend the H-1B after I travel back from my home country?
Yes, no issues with that. You can transfer to a new employer. And the same thing with L, you can extend the L1 if you have time left on your 5 or 7-year limit, and you can extend the L2.
Can my wife switch to H4 to H1B? I switch to H1B to H4 after returning back on advance parole.
Yep, absolutely.
Now, am I on advance parole? Am I on H1B when I come back to the United States?
That is a $1 million question that we don't have an answer to. It was left unclear in the guidance memo that USCIS put out about 20 years ago. And they said they would clear it up in the AC-21 regulations, which they never did. So the issue's never been addressed, but it's also never an issue for anyone. No one ever asks. Like, it's always the client that's asking that question, but no one from immigration ever asks, well, what status are you in?
Do I need to update my I-9 with my company if I travel outside the country with the new I-94 with advance parole?
No, that's another thing. A lot of people think that in-between changes that happen require the I-9 to be updated. That's not true. The I-9 only has to be updated when whatever document you gave last is expiring. So if you come in on advanced parole and you have an EAD, that doesn't mean that you now have to give your HR your EAD copy and change your I-9. That you wait until the H-1B is expiring, and at that point, you either use the new H-1B extension that you got, or you can give your EAD at that point.
So wait a minute. I come back on I come back on advance parole. I can extend the H-1B. I can transfer the H-1B. I can amend the H-1B. I can move to the another visa called H4 or whatever visa I'm eligible. And I don't need to file the I-9 amendment. That looks to be H-1B. Why you keep insisting saying that, hey, I'm on advance parole? It's a way perception every lawyer looks. Emily and I disagree on that particular thing. She thinks that I'm on advance parole. I think I'm on H-1B. There's nobody to judge us right now at this point of time. So it's up to your interpretation, what you want to interpret, how you want to interpret, whether it's a H-1B or advance parole. But the government is not asking that question. So you're fine to interpret that you're on advance parole or a H-1B or H4.
Lastly, we wanted to talk about what happens if your company is sold. What if there's a merger, some kind of acquisition? What does that do to your H-1B? What does that do to your Perm? What does that do to your I-140 or your 485? And the first thing you have to look at is, does whatever the change in ownership qualify as a successor in interest? So you have the company as it was when you filed your H-1B, when you filed your labor, when you filed your I-140. And now there's a different entity, whether that's because someone bought the old company or they merged it into a new company, or there's a new entity that was created and that bought the old company. There's all kinds of different transactions that can happen But you first need to determine, is the resulting company a successor in interest to the original company? A few things that we look at is whether the tax ID number changed. If there was no change in tax ID number and just ownership change or a name change or something like that, most likely it has very little effect. If it's a new tax ID number, then we have to look at, okay, did the new entity take on the ownership or part of, was there a spin-off of a business unit and now the new entity owns that, but they're carrying on the same business. They intend to take on the liabilities of their employees, of the immigration compliance. They've agreed that they're going to be in compliance with the LCAs going forward, and they agreed that they're going to offer the same job for purposes of labor certification. So if the new company does qualify as a successor in interest, no H1B amendment is required, no H1B transfer is required. The only thing the new company has to do is update the public access file to show how the transaction occurred, which LCAs are impacted, which employees have moved over to the new entity. In terms of a labor certification, if you have the labor certification filed by the original company and it gets approved, and now the new company is getting ready to file the I-140, that's totally fine. Just when the I-140 is filed, the new company shows how it's a successor in interest. If the I-140 is already filed and approved, that's where an extra filing is required. An I-140 amendment has to be filed so the government can confirm that the new company is offering the same job under the same terms and conditions, has the ability to pay, and that it actually is a successor in interest. So that's really the only one that's impacted the most.
So the question, sir? Question that's coming from Patil from YouTube. What if the I-140 gets rejected? Can the Perm needs to be refiled, or if the I-140 can be filed with the same Perm? Multiple things, confusion about the question. Is it rejected or denied? Rejected means normally when you don't pay the proper filing fees, you use the old form, it gets rejected. So if it's rejected, that means not being accepted and RFE and denied. It's denied is when you accept it, issue an RFE, and they will deny it. That's one thing. Rejected means when you don't put the proper check, they will reject it. So if it's a rejected because improper check or something like that, you can always refile the I-140 application if it is within 180 days from the time the Perm has been approved from. But if it's been denied, then first of all, we need to look into the reason for denial. For example, if by any chance the denial is because of the ability to pay or some issues that can be corrected at a later time, then refiling probably would cure the I-140. Even though 180 days have expired here, once the Perm application has, once the I-140 has been filed using the Perm application, accepted by the USCIS, that means fees are accepted, that Perm becomes live forever. So it can be reused again to file. So if it can be corrected and been approved, yes, you can use the same Perm again to refile the application. But sometimes what happens, it may not be strategically a good point. For example, if there is a 3-year degree and the person has filed under EB2, if the I-140 gets rejected, normally strategically what we do is that we refile the Perm application and get the I-140 approved rather than using the same Perm application. So it will depend on a lot of different circumstances. Reddy has this question from Facebook, Sridhar Reddy. What he has is that, is it mandatory that the employee stay with the company for more than 180 days after the I-140 is approved? What he is intending is that to use the I-140 approval, to use the I-140 approval to extend the H1B, to file the H4 EAD, you can't have the I-140 withdrawn within 180 days. The rule says that the company should not withdraw within 180 days. But it never says whether you should be staying with that company or not. So irrespective of whether you're staying with the company or not, if the company withdraws the I-140 within 180 days, you may not be able to use that I-140. But if they withdraw it after 180 days, irrespective of whether you're working for the company or not, then you're in a good position.
Avi says the prevailing wage determination has been pending for a long time. What should we do? Yeah, unfortunately, that is, we're just continuing to see these long prevailing wage determination timeframes. It started back in October 2020 with all of the people that were taken by surprise with the October 2020 visa bulletin and had just changed jobs. And so all these employers were having to submit new prevailing wages so that they could take advantage of the dates. And then we had Trump trying to change the prevailing wage calculation. So everyone was hurrying up to submit prevailing wages using private wage surveys. And then the Trump administration got blocked. So they went back to the old way and they had to go back and reissue all the wages that they issued under the new provision back under the old provision. And as the dates kept moving, more and more people tend to start the labor certification process. So all of that has, and they changed the SOC codes, all of that has led to these really long processing times. They're not adding resources to it. They don't get money from filing fees because it's a free process. So they don't really have additional resources in order to fix that. They've also got to deal with the H2B window that's open, and they have to process those prevailing wages and labor certifications very quickly. So all of that to say, there's not much we can do. We've looked into litigation. I do think it's an option, but it needs to be the company that's filing it, because the prevailing wage itself, the beneficiary, the employee, is not mentioned anywhere on it. It's not for the employee, even though it will ultimately be used for your labor certification. The prevailing wage is not tied to a particular employee, so that makes litigation a little tough.
Emily, I need a little bit assistance from this question from Kalyan Kumar from Facebook. His first H1B has been denied at the USCIS while on L1A visa. Have you ever been refused a US visa? The answer is simple. Since the USCIS denied your H1B, though, to answer the question, have you ever been refused a US visa? The answer is no. The answer is no. But what if, Emily, I got a 221G when I went for stamping in India? They didn't deny, they didn't refuse, they issued a 221G. What should be the answer for me in the 485 application for the same question, have you ever been refused a US visa?
Yeah, technically, even though it's a 221G, they're saying administrative processing, which makes it sound like they're still processing the case. A decision hasn't been made. A 221G is a denial. So you do need to disclose that in future DS-160s as well as on the I-485 application.
Tarak has this question. Is the fee hike applicable for the H1B quota for this year? Answer is no. It is not applicable for the year. Absolutely not applicable.
Vinod says, we just completed our green card interview, but the priority date is not current. Can I move to the EAD to work for a different employer, but my AP is not approved and I'm a dependent? I mean, technically, yes, you can do that since you have the EAD, and if you are not the main applicant, there's not really any problem with you changing jobs and using the EAD with a new employer instead of your other status. The only issue is with the AP not being approved. If you were on H1B, you would have the ability to potentially travel if you can get a visa interview appointment. If you switch to EAD and then you need to travel, you have to wait for that AP to be approved. So if it's an urgent travel need, you would have to go through the emergency advanced parole request, which is still not fast and it's discretionary. So that would be my only concern, is maybe it's a little safer when you have that AP in place, but technically, yes, you can work for another employer.
Vidut has this question. He is originally born and Indian citizen born, but he went to Australia from 2013. Now he's an Australian citizen. Is he eligible for the green card in the rest of the world? Answer is no, you're not. It's the country at the time of your birth that will determine, not the citizenship. However, Vinod, though, there is something else that you need to understand. When it comes to the immigrant, that is the green card, you are considered to be an Indian. But when it comes to the non-immigrant visas, you will be considered to be an Australian, though, not Indian. Thus, you're eligible for a visa called E3, which you may want to use it because H1 is a little bit, there's a lottery system and all those things. E3 is more easier. You may want to use the E3. You may also be eligible for E2 visa also if you want to pursue that option. So those things that E2 and E3 are not available for Indian nationals, but they are available for Australian citizenship. So then for non-immigrant purposes, you will be considered to be Australian citizen, but not for the green card purposes.
KK moved to the US in 2014 on H1B. He's got the EB2 I-140 approved with a 2019 priority date, and he wants to upgrade to EB1C because he worked as a manager internationally for more than a year and wants to know if he's eligible. The first question would be, when you came to the US on H1B, was it for the same company that you worked for abroad as a manager? You have to make sure that there's a qualifying relationship between those two companies. And then is the US affiliate of that company now offering you a managerial position? So if both of those are yes, then you may be eligible for it. But if you worked for a completely separate company and then have been in the US, then you would not be eligible because you had to have worked for the company abroad for 1 year in the last 3 years, unless you came into the US for that same company. Then you can look at 1 year in the last 3 years before you entered to come to work for that company. So a couple of caveats there, but it may be possible.
Retrospect has a question, how can we contact your law firm? We do have a link at the bottom where our appointments are available. Emily's mine and rest of our very good team that is there. All these appointments are available there. So you can go there, our schedule is there, you can block any time that suits you.
Dharmic says, what are my options if my company is not willing to file the Perm for the green card? I have only 2.5 years left on my H1B. Probably your best option is to find a new company as soon as possible, or find another company that is willing to file the Perm for you without you joining them. Beyond that, you can buy additional time on H1B by taking trips outside the US and then recapturing that time later. You can change status to another type of visa if you qualify for it, to have extra H1B time later. But ultimately, otherwise, once you hit that 6-year limit, you have to exit and wait 1 year and then go through the lottery again, which is probably a quite different process than when you went through it 3.5 years ago.
Retrospect has this question. My Perm has been denied because of lawyer's error. I wasted 2 years. No longer trust. Can we go through your law firm? Yes. We are proud that we consider that our Perm labor is the best in the entire USA. The reason why we say is that the way our office is divided is different than that of the rest of the law firms. I don't know why we structured it. There are some advantages, there are some disadvantages for that. The way our office works is that there are some lawyers who work only on H1B. There are some lawyers who only work on Perm applications. There are some lawyers who only work on I-140. There are some lawyers who only work on 485. There are some lawyers who work across the board too, but most of our lawyers are segmented only to one particular segment. We have a good team of 4 or 5 lawyers in Perm application. 5 lawyers in Perm application. They only work on Perm applications. 90% of their duties are only Perm applications. Because Perm is a very sensitive case. There are a lot of dates to remember, a lot of things to remember. Our office, from the beginning, we structured ourselves to be only Perm, dedicated team, and our legal assistants who work in the Perm, they don't do anything else other than Perm. Within the Perm itself, then the legal assistants are divided into different teams. One team is for only recruitment, one team is to the efforts, so one team is to collect the information. So all these people are divided into different teams. They have a lot of experience in our legal assistants, have a lot of experience in our thing. So we consider it to be one of the best in the United States in the Perm. So yes, please contact our office. But when you make an appointment, please do not make this lady appointment or with this guy, because I have not done Perm in 15 years. Emily does sometimes, but there is a lady called Crystal Alinas. She is the head of the department. make an appointment with her or any of the labor department lawyers. So when you go to the appointment, we give a categorization. Who is Perm? Who is H1B? Please pick those people though. If you think so that that is the issue, don't pick Emily or me for the Perm, because believe me, these people do Perm much, much more than Emily, and I have not done a Perm or labor certification application I haven't done it for like 20 years. So now if you tell me to do the Perm, no, I won't. It has to be passed to you. So it's better that you directly go to her.
Yeah, and Crystal is known among the legal
We
community
call
as
the
the
Perm
Perm
Queen.
Guru.
Queen.
And she was just quoted actually today in a Bloomberg article talking about what happens when the Perm process can't continue. How does that impact those that are maxing out on H1B? So you can check that out. I think we posted it on our social media on Twitter and LinkedIn for sure. So you can read her quote there in that article. Priyank says, I'm on EB2 using my EAD. Can my company apply for the I-140 approval in EB3? Yes, they can. So assuming that you are meaning to refile that same labor certification in EB3 instead of an EB2, refile the I-140 using the same labor certification, they can do that. And then once it's approved, if your EB3 date is now current when your EB2 is not, that's the point when you can do a transfer of underlying basis to downgrade to the newly approved EB3 I-140 approval. There's not a great process for that whole downgrade situation, but I mean, we used to do that all the time, going from EB3 to EB2. People would start off in EB3 because they didn't have 5 years of experience yet, and then we'd have the 485 pending and priority dates retrogressed, and then they would later have 5 years of experience, change employers, file a new labor, file a new I-140 in EB2. We would transfer the underlying basis to move them into EB2. Their date was instantly current and they would get the green card.
Question with regards to Kiran Kumar from YouTube. Is there anything we can do about the delay of the Perm labor certification? One, the court litigation is an option, guys. That's definitely an option. There are other tricks and trades that we have. We put an article on it. We put a YouTube on it where you can spend some time outside the country. H4 EAD might be an option that you may want to consider if you're eligible for. There are tips that we have given in there. What I like people who are coming to 3 years end though, to contact an immigration lawyer if your labor and I-140 is not yet applied. Because there are some things that you could do when you are at the 3-year mark. Don't come to me at 5 years and 11 months and 28 days. Rahul, what can you do? Okay, that's not a good option though. The best thing is at the 3-year mark, if your labor and I-140 is not filed, okay, you may be in trouble because it takes 2 years, up to 2 years for the people to file the green card application. And Retro Prasad has this question, can you do it expeditedly, Perm labor certification? First, we have to go through the prevailing wage. There are some exceptions, but they are very risky exceptions. Prevailing wage takes approximately 7 months. Then after that, we can reduce the recruitment time because while the prevailing wage is coming, we can start the recruitment. It can overlap to a certain extent. It can overlap. So the minimum time that it will take a boat is 7 to 10 months is the minimum time, I would say. But if the company is not willing to do the recruitment while the prevailing wage is going on, it may take approximately 12 to 14 months to even file a labor certification application. And once the labor certification application has been filed, well, that's not the end of the deal. Then they are taking approximately 7 months to approve the labor certification approval. So you're speaking of approximately 2-year process is the labor certification taking. Now, I know you might have spoken with your old friends that have been here for a long period of time. They got their Perm approval, everything from scratch to everything to in probably 3 to 4 months. Yes, it may be true, but now the time is approximately 2 years, if not more. So by 3rd year mark, if you did not file the labor certification, you may be in trouble. You may want to contact the lawyer. First, you need to contact your company to get that labor certification. If they're not doing it, you may want to contact outside lawyer to see what are the other alternatives that you could do.
Ravsha says, can I travel while my AOS is pending? I have an approved L1A, but the visa is not stamped. My L1A was extended by using Nunc Pro Tunc within 3 months after the I-94 expiry. So I would want to confirm that your L1A extension approval notice had a new I-94 on it, that it was not approved for consular processing. If it had the new I-94 on it, that puts you back in L1A status, and they're using their discretion to overlook that 3-month gap. In that situation, yes, you can travel without impacting the AOS, but only if you can get an L1 stamping appointment, because you need to get the L1 visa to come back. So you either have the choice of going and coming back on L or going and coming back on AP. So if you can't get the visa stamping appointment, then you are going to need to wait for the AP in order to travel.
Bobcat has this question from YouTube. Can I file a EAD application along with the I-140 current processing because of the current processing of for the H4 EAD? No, you cannot file the EAD when you're filing for I-140. Multiple reasons. One, the address is different to file for H4 EAD than that of I-140. Second, by the time you file an I-140, you must have had, I'm assuming your spouse must have an I-140 approval already to file that. So for both the purposes, it's not advisable to, I don't think so they'll approve the EAD if you do so.
Aryanesh says, if you have the EB2 I-140 approved with company A and you shift to company B and the priority date becomes current, do you have to again go through Perm and I-140, and can we concurrently file the 485? Yes, you do have to go through the Perm again. That's exactly what happened to a lot of people in October 2020. The job market was great. They made the jump to a new company. All of a sudden their date became current and they're like, I can't file my 485 because I left that company and I don't have the new Perm in place. So you have to go through the labor certification, taking 2 years to get through that process. And then once the labor is approved, you can file the I-140 and 485 concurrently, assuming the date is still current. You may want to consider filing just the I-140 first, getting it approved, and then filing the 485. That's based on our experiences going back to October 2020, when the concurrently filed applications were taking 2 years, and the ones that were filed one after another were taking 3 months to get the green card. Now, of course, you would need to look at what the current trend is at the time you get that labor certification approval. But you do have the option of filing concurrently if the date is still current by the time you get the Perm approved.
Atra from Facebook has a question. Can the visa recapture be done with the executive order? What probably you meant to say is that, can this administration do the unused green cards for the employment base that have been wasted out? Can the administration do without going to the parliament? They call it as Congress here. Yes, they can. I believe so they can. They can also stop counting the family members. So both of those things can be done by the administration. We should target it. We put a draft at the bottom. If you can modify a little bit, please write that thing to the administration so that they stop counting the family members and probably start recapturing the green cards that have not been used. There are approximately around 300 to 400,000 green cards that were not been used for the employment base. They can be recaptured.
Wesley says, is the 485J supplement considered as sponsorship? Many employers are posting jobs with no sponsorship. Is the 485J something that can be filed by the employee, or do we need the employer? It is not sponsorship. So that's something to make very clear to a company if that company is not familiar with the 485J. All they're doing is signing that form confirming that they have a bona fide job offer for you. They're not sponsoring your green card. They're not having to, prove that they're going to continue to offer you that job and they're going to keep you employed. It's not tying them into you in any way. It's just a form confirming what the job offer is and that they do have a job offer for you. But it does require the employer to sign. You can't submit it without an employer. employer.
Emily, I have a couple of questions on that. Is it mandatory that when I join the company that they have to file a 485J, or can it be done later on?
It can be done later on. We had in the past recommended doing it proactively when you join, but the current adjudications in trend is to now wait until you get an RFE or get called in for an interview.
Emily, what about, is there a filing fees for the 485J supplement? And can the legal fees be paid by the employee instead of employer in the 485J supplement? Or is there a restriction that has to be paid only by the employer?
Right. There is no filing fee, so it's free to file that with USCIS. If an employer is preparing it, there would generally be a legal fee, and that fee can be paid by the employee. There's no requirement that it has to only be paid by the employer.
And that's the reason Emily was pointing out that it's not a sponsorship, it's just a confirmation of the job duties. That's all it is. So, you may want to say that you don't need any sponsorship to go join them. That may be a better way. And then when there is an RFE or when there is an interview, at that point of time, then you can request the employer to confirm that there is a job offer in a different form rather than just a paper, which they normally give. So.
Devis says the 485 primary application is still in the National Benefits Center, but the derivatives applications moved to the Texas Service Center. Is this normal? Anything I can do on this? I wouldn't say it's normal, but we've seen time and time again where the main applicant and the dependents applications get split up for whatever random reason. Doesn't seem to be any reason at all. It does happen where they end up in different offices. Anything you can do about it? I don't think so. It's up to USCIS and how they decide to process it. I do feel most of the time it's done in error, but we don't have any control over how they move cases around, and we can't force them to move them to the same place or keep them together.
Pratap Cheripuri has this question. Change the employer attending the GC interview, taking 485J. For AC21. Yes, absolutely. You need 485J supplement if you change the employer. Now, if you are with the same employer though, you can take the 485J supplement. I normally send them only with the employment confirmation letter, not with the 485J supplement. But if you change the employer, you must have the 485J supplement. For the interview, you must take the 485J supplement for the interview.
Chitin says, when filing for my H1B extension, can my wife file a change of status from H1B to H4 and do the H4 EAD together? And can she keep working along with the change of status? So yes, she can file the change of status from H1B to H4 and the H4 EAD along with your H1B extension, as long as you have the approved I-140. She can keep working in H1B status as long as the H1B has not yet expired and she's still working for the same employer under the same terms and conditions. When would she have to stop working? That would be if she changes employer and does not have the H4 and EAD approved yet, or if her H4 gets approved but the EAD is not yet approved. Then she has to stop working because at that point she's in H4 status and has to wait for the EAD to come in. But that's pretty rare nowadays. For the H4 and the EAD to be processed separately and not approved together.
Can I get a 3-year H1B extension if my priority date is current but with the previous company? New company will take some time to file the Perm and I-140. The answer is you are eligible for a 1-year extension or 3-year extension if the final action date is current. One of the options what I would recommend when the priority date is final, when the date is current for you guys is always try to call the old employer to see if they are going to help you out in filing the 485. Believe me, there will be a lot of employers that do that. That will resolve a lot of problems of you. And I will go and join the old company. Even if I have to take a 50% cut, I'm going to go there. I don't want to keep coming to the Reddy Neumann's channel every week until I get my green card. Once you get the green card, you can get it off us. So yeah, just contact the old company to see if that option is available for you.
Neha says, how can one apply for the compelling circumstances EAD? So this is for someone who has an approved I-140 and for whatever reason they may be falling out of their H1B status, they may have been terminated or something like that. And if they can show that there are compelling circumstances the government will issue an EAD to allow you to continue to work and legally stay in the country, even though you're not in an actual non-immigrant status. Where this is most helpful is usually for the situation where your I-94 is expiring and you may not qualify for the 60-day grace period. I do recommend we have a separate video on our YouTube channel. If you type in compelling circumstances EAD, you'll find it. It's a short video that explains the process and who qualifies. And then if you want to look into the option of filing that, I would recommend Ryan Wilk in our office. He is one of the attorneys that handles the I-140 and I-485 applications, but he also does all of our compelling circumstances EAD cases. He's been able to get a number of them approved since COVID times. So you can check with him on that.
Rupak has a question. My spouse H4 I-539 is pending. It's not yet approved. Can I apply the EAD with the receipt notice of the H4, or do I have to wait for the H4 to be approved? No, you can file with the H4 receipt notice. You do not have to wait for the H4 approval to file for the EAD, assuming that she's eligible for the H4 EAD.
Another question with H4 EAD is, can we file the H4 EAD along with the I-140, and what's the current processing time for the H4 EAD? You can't file it with the I-140 itself. You have to get the I-140 approved first, and then you can file just the I-765 if you're already in H4 status, or you can file the I-765 plus the H4 if you need to extend the H4 status as well. The way to get them the fastest is, once you have your I-140 approval, file the I-129, I-539, and I-765 all together. Thanks to our settlement with USCIS as a result of our class action lawsuit, USCIS is now required to process all three of those together. So if you filed the H1B in premium processing, you can get all three approved in premium processing with just one fee. If the H4 EAD is filed by itself, it's probably 6 to 12 months right now.
The good part about this litigation for the H4 EAD, where we are the lawyers who did the class action, we're going to get paid from the USCIS and for doing good for you, and we're getting paid for the USCIS for what they were doing, continuously bad thing. To stop doing their bad things, we are getting paid from them, which is a good victory. We feel very proud about it. Priority date prediction is going to be very tough. We are not expecting a lot of movement in the final action dates because the number of applications pending are too much for Indian nationals. Previously, the USCIS used to publish that how many people in India are pending with the priority dates. They used to give April so-and-so year, so many Indians 485s are pending. May so-and-so year, so many Indians were pending. They're not releasing the data that they used to do it before Trump administration came in. So now we don't know how many cases are pending. Let's say, for example, in July of 2012, how many EB2s or EB3s are pending from Indian nationals? We don't have a clue. So it's very hard to judge the priority date movement. All we can say for sure, I mean, not for sure, but all we can say is that to move to 2015 seems to be very unlikely under the current circumstances.
Funny has the H1B approved until October 2023 and a pending 485, and the 131 advanced parole is also pending. Just got the 765 EAD approved today and wants to know, can I travel outside the country? I don't have the valid visa stamp. So you have two options. You either need to wait for the advanced parole to be approved and then travel on advanced parole, or you need to schedule the visa interview appointment or Dropbox appointment during your travel and apply for the new H1B visa stamp and then come back on H1B. If you choose the H1B option, it does not impact your 485, but your pending I-131 will likely be denied for abandonment, and you'll have to refile that, which is going to take another year for that to be approved.
Krishna has this question about margarita switch. When does it work? When does it doesn't work? First thing, for the margarita switch between H1B and H4 though, you must have the H1B approved with the I-94. You must have the I-797 approved for the H4. These two things need to be there. If you want to switch from H4, which you wanted to H1B, you must already have the H1B approved with the I-797, and you have not left the country you must not have left the country when you got after the H1B is approved. You have not left the country and went to India. You can go to Mexico and come back, but not to India. So if you have the H1B approved with the I-94, and now you have the H4, you are on H4 right now. The H1 with the I-94, you can take it, and then you can go to Mexico and come back and show the H1B approval with the I-94 to enter back. That will allow you for the margarita switch. You don't need to have H1B stamping to come back into the United States. Now, the other thing is that, of course, the main important thing is that you must be working for that company that has H1B. For example, you're on H4 right now, you're working for Microsoft. Your H1B is with Apple. And you don't have any job with Apple. Can you go to Mexico and come back on H1B with Apple? No, you can't, because you don't have a job with Apple. That entry will be illegal if you try to show them the Apple's H1B and trying to come back because you don't have a job with Apple. You must have had a job with Apple to come back with the valid H1B with the I-94 for the margarita switch to work.
Casey says, if I file for the H1B extension, how long do I need to wait before I can travel to India? I'm looking for premium processing. You do need to wait for it to be approved, and then you can travel. And then whether, it depends on whether you have a visa stamp or not. If you have the old visa stamp and it has not yet expired, you can travel that way. But make sure you show the new approval notice when you come in so that you can get the I-94 end date from CBP on the one that you look up on the website needs to match the one on your extension approval. So you can either do that or travel first and then file for the extension. I don't recommend traveling while the extension is pending. That can create issues with different I-94 numbers if you come in while the extension is pending, and what if there's an RFE while you're out, making sure that gets responded to timely. So either travel first and then file it, or file it, get it approved, and then travel. And then Shiva says, I traveled back to the U.S. using my AP, and at the port of entry, I got the new I-94 with an end date of January 17th, 2024, but my combo card expiration date is August 2024. When should I apply for the extension of the EAD and AP? This is the only time where you can ignore the I-94 date. Don't go by the January 17th, 2024 date. I'm assuming you came in on January 17th, 2023, just recently. They only give you 1 year, but as long as your 485 remains pending, you can ignore that 1 year and go by the expiration date on the card.
Chetan has this question. My I-140 has been approved with company A. Now I have moved to company B. Can I apply H4 EAD for my wife using the company A's I-140 approval? By the time company B files the form, an I-140 may take a long time. Assuming that your I-140 has been approved for more than 180 days, not been withdrawn by company A, absolutely not a problem. You can file using the company A's I-140 approval to extend your wife's H4 EAD with company B or company C or company D. You absolutely can do it, no problem. It doesn't have to be with the same company that you're working. Your I-140 doesn't have to be.
Kieran says, these days USCIS is giving the I-797 approval notices with a future date, like July 2023 to June 2026. How does that affect my wife who's going for stamping now? What will they do with her I-94? So the H1B extension approval starts in July, but if you're currently on H1B, she can still go for stamping and show both approval notices and get the stamp till June 2026. And when she's entering the country, she can again show both approval notices. So even though she's coming in before July, show both approval notices to get the end date of June 2026. Sometimes CBP messes that up, so you have to look at the date that they put there and maybe have to go back to deferred inspection to get it fixed. But they should be giving that full time period.
Sandeep Nadella has this question. Is advance parole only to travel to the home country, or can I travel to any country in the world with advance parole? It allows you to go and come back to any country. absolutely. You can go to Europe, you can go to Russia, you can go to any country. But of course, to go to Russia, you need to have a Russian visa. But that's a different. We don't deal with that. But as far as you coming back from Russia, you coming back from Japan, you coming back from Ukraine, you coming back from South America, Mexico, Canada, you absolutely have no problem. You can come back. That is given for you to come back into the United States. It doesn't tell that you have to come only from your home country.
Newer says that H4 withdrawal was sent in December 2022 while it was pending, but the status hasn't been updated yet to show it's been withdrawn. We later filed an H4 in January and got the receipt notice. Would USCIS consider the latest filed H4 and ignore the previous filed H4? They will not ignore it, the previous H4. They will adjudicate it like they normally would. If they happen to see the withdrawal request while they're adjudicating it, then they will close that case because it's been withdrawn. And then later, when they get around to the new processing dates, they'll then look at the new filing. But if it's not, if they don't see that it's withdrawn, they're going to just process it as if you never withdrew it. So just keep an eye on that if it impacts your underlying status, or I don't know what the reason for the withdrawal and refile was. But just be aware if they haven't processed that withdrawal, it's kind of things are, the right hand doesn't know what the left hand is doing. They'll still process it.
Question, my Perm labor certification recently got approved. My priority date is December 2011. Should I apply an EB2 or EB3 labor certification? I-140 application though. Since the final action date for the EB2, since the final action date for the EB2 and EB3, both are current for you though. That's going to be judgment call. To apply in EB2 or EB3, it's going to be judgment call. Whenever I get into trouble though, I normally go to my spouse and ask the question and have her do the coin toss if she still cannot tell me. I would suggest you do the same thing. If she is correct and she does the correct answer, I should get the credit because I have pointed out to your wife. Okay? And if she does wrong, we both will go and blame her. This is very hard to predict whether EB2 is going to move forward, EB3 is going to move forward. That's the reason we need to get involved our spouses so that if the judgment call goes good, then we can say, we picked you, okay, that's the reason you got it right. And if it goes wrong, we can blame the spouse. In this case, that's what I will do with the priority date of December 19, 2011. I would pick, Satish, pick your wife. Let's see what she says.
Sudeep applied for the H4 EAD renewal while it was still valid, but then there was an H1B termination that occurred, later moved to B2, and now back in the US, back in H1 and H4 status through consular processing. He wants to know, what are the chances of the EAD approval? So I think that based on where you're at right now, you would have re-entered on H4, so you have a valid H4 I-94. And you also have an EAD renewal that was filed before your current EAD expired, I'm assuming. So that means you should be eligible for the automatic EAD extension, the 540 days. Now, there are some chances that that EAD could be denied, particularly if the prior employer withdrew the H1. Sometimes they automatically assume that there's no new H1 in place and deny the EAD because of that. It could be because they see that you changed status to B2. I don't know if that B2 was actually approved. I'm assuming not because the time, it takes too long to get those. But if that was approved, they may think this person is no longer in H4. We're not going to approve it. So for those reasons, you may want to consider spending an extra $410 to file it again, just as a backup plan. So you can rely on the pending one to use the auto extension and keep working. But if for some reason that happens to get denied in the future, you'll already have the new one pending and can hopefully minimize the amount of time where you don't have that work authorization.
Shivani has this question that if you are a Canadian permanent resident and Indian citizen, but Canadian permanent resident, is there any special kind of visas available for them? Unfortunately, no. For Canadian citizens, you are eligible for the TN visa and E-visas though. E-visas is Canadian, yeah. But for the for the permanent residents, you are not eligible for any kind of visas to come and work in the United States. It's the same thing like Indians H1B and other things, but the e-visa eligibility and the TN visa eligibility, you are not eligible for them because you're just a PR. You're not a Canadian citizen.
All right, well, we are out of time for today. Thank you so much for joining us. We'll be back again next week, Tuesday, 5 o'clock. You can also always join our daily conference call. Go to rnlawgroup.com to get the Zoom information for that. And I'd also love for you to join us on Instagram. We created an account there not too long ago. We share some more content on Instagram and a little more behind the scenes of what goes on here at Reddy and Neumann. So if you're an Instagram fan, you can go to @RNLawGroup and find us there and follow us and like us. And we'd love to interact with you there. Thanks for joining.